Hi everyone, this is Mr. Fokowski. Happy snow day to you. I'm going to go through today's lesson in, of course, a much more abbreviated format, but certainly please complete stages 1 through 4. Actually, I have to change that here. So start off with which court system, as this was based off of last week's discussion, whether you can identify these scenarios belonging in state district or appellate court, and there is actually one in which you can put the Supreme Court as the original jurisdiction. So of course try that. We'll review that briefly on Tuesday. We're going to go through our PowerPoint in a moment, and you should of course be plugging away with the summative review questions as we inch closer to your test. You will have a quiz this Thursday as well, so please be prepared for that and the readings that were assigned for last week that are due this week. So under part 3, involving the federal courts. Let's go through that right now. You can follow along in your binders as well. Okay, so when we look at the judicial system, there are, of course, two types of cases, which I'm sure you've heard of before. You have criminal law, which involves charges being brought against an individual for violating one or more specific laws. So the government is formally charging this individual with whatever crime. In contrast to criminal law, civil law is when there's really no charge of criminality. The government is not involved in trying to, eventually put you away in jail or, charge you formally with something. But this is when it involves one person, and that one person is accusing another of violating his or her rights. And the burden for proving that guilt or that violation of that particular right is much less when you compare it to criminal law, because in criminal law, when you're going to find someone guilty, it has to be without a reasonable doubt. In civil law, the burden is much less. So overall, the U.S. government is involved in about 2/3 of all cases brought to federal court, either as a plaintiff or as the defendant. I mean, that is a heck of a high number right there. Over 67% of the cases right there involves the United States. That could be the United States charging someone with a federal crime. That could be the United States being sued by a citizen. So there are many, many different ways in which the U.S. government can be a party in the judicial system, and it often is. So again, when we look at criminal law, crime, punishment, government as prosecutor, proof beyond a reasonable doubt, whereas civil law, you'll see that the punishment is not such as incarceration or death, such as death penalty, but it's compensation. You're suing for a sum of money. It could be an injured person, such as the plaintiff, so you're not really involving a prosecutor here by any means. And as I said earlier, the proof is much less. You just have to have a preponderance of evidence that, even if it's circumstantial, that could be enough to render a favorable verdict in favor of the plaintiff. So if we look at the participants in the judicial system, this of course seems a little obvious. You have the plaintiff, the defendant, and the jury, who are typically always there for criminal and civil matters. But also something that's very important and you need to make note of is the standing to sue. You have to have a serious interest in a case in order to sue the government or to sue anybody. So if you're not really directly impacted, you can't sue. You have to have standing. If you don't have standing, good luck trying to bring your case. Another interesting aspect of the judicial system is that, for a case to go to court, it has to be deemed a justiciable dispute. This refers to when a case is able to be settled using a matter of law. So for example, if you're a disgruntled citizen, you're a hard-right social conservative and a fiscal conservative, and you don't want Congress to fund a social program, well, sorry, that's not a matter of law. So you actually have to be able to apply case law to this, not based on a citizen thinking that, well, in my political ideology, I don't think really Congress should be funding this particular social program. It's also important to state that this cannot be a hypothetical case. So Congress can't say, hey, Supreme Court, how would you rule on this, piece of legislation? It has to actually be a real law. Because if they had all these hypotheticals, think about how much more convoluted the system would be and how much more backlogged the courts would be. And, if you've read the news, you'll see that courts are very much backlogged because we are a very litigious society in which we are suing regularly people and the government. Another participant in the judicial system that's not always thought of is interest groups. Of course, interest groups use the courts as a last means to change policies because, again, the judicial system is a policy-making institution similar to the executive and the legislative branch. What's interesting about interest groups is that they will seek out the best litigants to represent the cause that they support. The best example of this is the NAACP in the Brown v. Board of Education, where they brought a class action lawsuit. And they found a particular litigant here, you see on the right-hand side, who they thought best would represent their case and explain how segregation is unconstitutional. And it worked rather well. So interest groups through class action lawsuits do very much have a place in the judicial system. Now, we know from our previous studies that interest groups can file what are called amicus curiae briefs in order to influence the court. So yes, this translates to friend of the court in Latin, but also keep in mind that an amicus curiae brief is to try to influence the court in some way by giving them additional points of view or information that may not have been contained by the two parties involved. And when we talk about lawyers in the court system, of course, that's the obvious part of the judicial system. I mean, think about the number of lawyers here today, 800,000. That shows, that how litigious of a society that we are. And really what, ramps up the number of lawyers, I would imagine, too, especially with public defenders, would be this famous court case known as Gideon v. Wainwright, which brings about public defenders that we have today, that everybody is entitled to a lawyer. Not just, if you can afford one, but even if you can't afford one. That's where our public defenders come in. So everyone is guaranteed a lawyer. Please make note of that Supreme Court case. There are organizations such as the Legal Service Corporation, which provides lawyers to assist the poor that are of higher quality. Sometimes public defenders are overwhelmed or they don't have enough time to really mount a good legal defense for their client. Because again, if you look at our judicial system, a lot of it is built around how much money you have. People with more money have better access to better lawyers and resources that, say, public defenders don't have. Now, the government also has lawyers that act on their behalf, and this one, the head lawyer, if you will, is the Solicitor General, who represents the government to the Supreme Court. So it's the government lawyer who is representing the government at the Supreme Court cases when the United States is a party. And of course, we have the Attorney General, who is the head of the Department of Justice. So it's almost like calling him the Secretary of the Department of Justice, but in this case, he's called the Attorney General. Now, the federal courts do have some constraints on them. Remember what we read about in Hamilton's Federalist Paper number 78, in which he says, this is going to be the weakest branch of the three because it doesn't have the power of the purse, nor does it have the power of the sword. And other issues into why it's not the most powerful branch is, well, this is a passive court, meaning that the case has to come to the court. It's not the other way around. Supreme Court justices can't say, oh, well, I want to change this piece of legislation. Congress could do that, but the courts can't. The case has to come to the court. And as we said before, that these cases cannot be hypothetical. You have to be actually able to settle these issues through legal matters. And last but not least, another big constraint involved political questions. So if the Constitution, can settle an argument or debate, such as, which group of officials of a foreign nation should be recognized as the legitimate government, that's not for the Supreme Court to decide. That is for another branch. That is for the executive of the United States to decide along with Congress, not the Supreme Court. So if it's a political question that really the Supreme Court or the federal courts can't decide on because it doesn't involve a matter of the Constitution in their specific realm, and it should belong to one of the other two branches, then they're not going to decide on it. And really, how could they, applying case law? So that is part 3 of the federal courts. So what I would honestly just ask you to do, go through the summative review questions, look through your notes, look through the readings that you had, and if you also have time, I encourage you to watch this particular YouTube video, as it is interesting about lawyers and the death penalty. This is a very funny scene from the movie My Cousin Vinny, which displays a public defender who you can see is actually not that competent. And even though this is a movie, it actually does touch upon reality in the sense that sometimes public defenders, aren't the best lawyers. Not to say that that is a statement true all the time. All right, so there you go. And keep in mind, 92 days until the AP Gov exam. We are, of course, inching closer. So please be ready for discussion tomorrow. And if you went on the website recently, I posted the final. No, I'm just kidding. I actually posted the Remind 101 text up here just in case you're not signed up. You can get them here 24/7. All right, see you in class tomorrow. Goodbye.